We're going to start with something close to my heart in terms of a person who's trying to get artificial intelligence to be a listed inventor in a patent application. Also, incidentally, trying to be a listed author in copyright applications. Okay, for some gut reason, this guy has a hard-on for the AI. And he'd really like the AI to be able to be an inventor unto itself. And so far, the courts have said no, including the Court of Appeals for the Federal Circuit has said no. But he'd like some further consideration on this issue. So we're going to go ahead and get started with this. All right, so computer scientist Stephen Thaler on Monday asked the U.S. Appeals Court for the Federal Circuit, which is the federal circuit that hears all patent cases. So all patent cases are heard by the Court of Appeals for the Federal Circuit. So they wanted some recognition on the patent law. So the Court of Appeals for the Federal Circuit is the one you go to, and they said no, not so much. You can't have it. He wants recognition for his artificial intelligence system, DABUS, to be an inventor, right? And no. Under the current law, you have to be a human being, right? You can be a human being who uses tools, and an artificial intelligence can be a tool to help you create. But there has to be some spark of humanity somewhere in this equation. And for whatever reason, he wants the machine to be an inventor unto itself. So, no. He is challenging a ruling by the U.S. Court of Appeals for Federal Circuit. The Patent Act does not allow patents for AI-based inventions because it interprets the term individual as meaning a natural person. Merriam-Webster favors our definition of individual, he told Reuters. Yeah, but the question isn't what the dictionary necessarily says. The question is what the law says, right? And what does the law mean? And what did the Constitution mean when it talked about to authors and inventors, to quote Article 1, Section 8, Clause 8, the intellectual property clause of the Constitution? Congress shall have the power to secure for authors and inventors limited monopolies. Authors and inventors was the language of the Constitution. What did they mean in 1791 or 1788 rather? What did they mean by authors and inventors? Do we think we meant people? I think we meant people. So yeah, not so much. Thaler's attorney told the Court of Appeals for the Federal Circuit this is not consistent with the Supreme Court precedent. It totally is, in every possible way. Or the language and purpose of the Patent Act. It totally is, in every possible way. Thus, also compatible with the Constitution, as I was just quoting. The United States Patent and Trademark Office has declined to comment because they really probably think in their head it's stupid, and they've already kind of said everything they want to say on this issue in court, and the Court of Appeals for the Federal Circuit has already ruled in their favor. Thaler used DABUS. Now, see, this is a bit of a misnomer from Thaler's point of view. Thaler used DABUS, the device for autonomous bootstrapping unified sentience, to create designs for a beverage holder and light beacon. Right? Now, the question isn't if he used DABUS, right? That's not what he's claiming. He's not claiming that he used DABUS, right? Because you can use a tool. You can use a hammer, you can use a saw, you can use a computer program, you can use anything that will help a human being create. And it can help quite a lot, as long as there's a spark of human ingenuity in there somewhere, right? So if he had said, I'm the inventor, I, Thaler, am the inventor, and I have used this artificial intelligence software as part of my invention mechanism, then he should be fine. But that's not what he claimed. He didn't claim that he used DABUS. He claimed that DABUS is acting independently. So that's kind of the problem. The article manages to screw up the issue in its own characterization. That's fun. The PTO and the Virginia courts have recognized the application. He challenged the decision before the Federal Circuit, which, as I mentioned, hears all patent appeals. So most federal issues are heard by a regional court of appeals, right? Texas issues, for example, are heard by the 5th Circuit, and California issues are heard by the 9th Circuit, and Florida issues are heard by the 11th Circuit, and Virginia issues are heard normally by the 4th Circuit. But this is a patent case, and all patent cases go to the Court of Appeals for the Federal Circuit. That's why they invented it. So anyways, he went to the Court of Appeals for the Federal Circuit, and the unanimous 3-judge panel said there's no ambiguity that the Patent Act requires the inventors to be natural persons. Yeah. I mean, yeah, obviously. He said the Patent Act requires them to be individuals, and individuals are human, citing the ordinary use and context of the Patent Act. Also, the Constitution, which, as I mentioned, talks about authors and inventors. Who do you think they were talking about? Probably talking about people. Yeah. Thaler requested a rehearing on Monday, either before a new panel or the full Federal Circuit. I'm sure the Federal Circuit will laugh in his general direction. He argued the panel ignored dictionary definitions, and the U.S. Supreme Court precedent says an individual is simply a singular entity and not naturally a natural person. In some contexts, sometimes, because sometimes statutes define words in particular ways, or even as between statutes, they can mean different things. A lot goes to what the word was meant to mean, depending on your statutory interpretation. But no. Thaler also argued that disallowing AI invented patents goes against the Patent Act's purpose to promote innovation. At minimum, the panel opinion should have wrestled with the ambiguity created by technological evolution and the results from prohibiting patents on AI-generated inventions. I mean, to promote progress in science and the useful arts is definitely the purpose established by the Constitution, but it still has to be a human being. Because, I mean, do you know how I know the Constitution speaks to human beings? You know one of the big clues is the Constitution speaks to human beings? One of the really big clues in the Constitution. I'm using the word big as a point of emphasis because what are the biggest words in the Constitution? Literally on the page, what are the biggest words? We the people. Yeah. So probably refers to people. Yeah. Courts in Australia, Europe, and the United Kingdom have similarly rejected it, but apparently South Africa, for some reason, is totally cool. So I guess in South Africa, at least, they are cool with the robot uprising. Thaler is going down hard. He's going down hard. The Federal Circuit has already laughed in his face once. They're going to laugh in his face again. It's a totally completely stupid thing. Nothing makes any sense.